Mr. Chairman. You know, I tend to think that updating ECPA in the manner that we proposed is essential to protecting the Fourth Amendment rights and interests of American citizens. I acknowledge that you, Mr. Chairman, led the original effort back in 1986, and I'm very happy to join with you here to provide these essential updates. For centuries, Americans corresponded primarily through the U.S. mail system. And, you know, it was well settled throughout that entire time that such private correspondence would be entitled to the full protection of the Fourth Amendment. Modern technologies now evolved to the point where third-party storage and cloud computing are now the norm. So countless people using Google, Yahoo, and other remote services to host and coordinate electronic communications have made it necessary for us to update this bill. Due to conflicts of older legislation and modern technology, private email correspondence over 180 days old is not accorded full Fourth Amendment protection, and today we're going to change that. Even the Department of Justice sees some need for this. In its March 19th, 2013 testimony before the House Judiciary Committee, the Department of Justice, through the Acting Assistant Attorney General for the Office of Legal Policy, said that there's no principled basis to treat email less than 180 days old differently than email more than 180 days old. Later on, referring to a theory that emails may lose warrant protection as soon as they're opened, the Department added, similarly, it makes sense that the statute not accord lesser protection to opened emails than it gives to emails that are unopened. Our bill prohibits an electronic communications or remote computing service provider like Gmail or Facebook or Twitter from voluntarily disclosing the contents of customer emails or other communications. It eliminates the ambiguous and outdated 180-day rule that some government agencies believe grants them warrantless access to the content of older emails. Instead, all requests for the content of electronic communications would require a search warrant based on probable cause, and law enforcement agencies would be required to notify within 10 days any persons whose email accounts are searched, subject to standard exceptions. Now, a few government agencies have complained that some provisions of the bill might unduly hamper civil and criminal investigations. That simply is not true. Routing information, customer names, session time records, and other non-content information would still be available through subpoenas. Executive agencies could also compel service providers to preserve records pending issuance of a court order preventing a targeted user from simply deleting his or her email. The bill also contains a rule of construction allowing government access to internal corporate email when the communications are to or from an officer, agent, or employee of a company, and the company is acting as the electronic communications service provider for its own internal email system. Finally, the bill adds civil discovery subpoenas to grand jury subpoenas, trial subpoenas, and administrative subpoenas as a method to acquire subscriber identifying information. So the Leahy-Lee ECPA Amendments Act of 2013 is truly bipartisan in nature and enjoys broad support from the tech industry, private advocates, constitutional scholars, and policy groups on both ends of the ideological spectrum. I'm grateful to you, Mr. Chairman, for your leadership on this issue, and I urge my colleagues on both sides of the aisle to support this legislation. Thank you, Mr. Chairman.
Mr. Chairman.
Thank you.